Welcome to the first edition of Consultation Latest Law, our updating service. It is primarily aimed at those over 1,000 of you who have attended the Consultation Institute's Law of Consultation course, which we've been running since 2012. For those of you who are yet to attend, maybe what follows will convince you that there is much to learn. My name is Elizabeth Gammell, and I work with Rhion and the team here at the Consultation Institute headquarters to monitor key developments in the ever-changing law of consultation. In this update, we will cover a significant judgment on the lack of consultation involving the NHS and local authorities in Hertfordshire. Secondly, we will review the case of Horton Hospital in Banbury and the important issues it raises, not just for the health service, and that one's going to appeal. Our third featured case is the important judgment on the politically explosive row in Haringey over a massive redevelopment, and that one's relevant to planners as well as consultation specialists. And finally, we've invited Rosa Curling of Leigh to discuss the issues we expect will arise in the forthcoming appeal in the case of the Dubs Amendment, obliging the government to admit young refugees. For these four cases, we have approached the lawyers involved so you will get their perspective. And at the end of this edition, I will ask Rhion to summarise the implications, and we will discuss what our members should consider in the forthcoming months. In the spirit of best practice consultation, we would be very interested to hear your views on this new online service and receive suggestions of information that you would find most useful. One of the most significant court decisions in recent months was in favour of campaigners fighting to stop the closure of a respite centre for disabled children in Hertfordshire. It's called Nascot Lawn, and we went to talk to Alex Rook of Irwin Mitchell, who fought the case.
The decision was taken quite some time ago, and there was initially a legal dispute about whether or not the CCG had a power or duty to provide these services, which for the purposes of this conversation about consultation is not necessarily that relevant. But what it meant was we got all the way to literally the week before a 2-day trial when the CCG agreed that what they had done was in fact unlawful and that they would retake their decision. They then retook their decision and decided to close Nascot Lawn again, and there was then a whole second judicial review, which then did go to trial, at which we were successful, and the decision was quashed a second time as to whether or not the CCG had followed a lawful process in order to close the service. And there were a number of grounds with which we said the CCG had not followed a lawful process. A significant part of that was about consultation, but that also, perhaps somewhat unusually, was kind of hived off in two different ways. One was, have you properly consulted with the local authority here? And another was, have you properly consulted with my clients, the parents and interested people? And it was the first of those two arguments that the court found in our favour, and agreed that the CCG had not properly consulted with the local authority before they took the decision, and therefore it was quashed. We were unsuccessful in the second of those arguments because the court found that they had undertaken what the court called as an engagement process as opposed to a consultation. But because we won on the first one, the decision was quashed. It's also probably worth saying that Nascot Lawn is still open and still running, and that consultation between the CCG and the local authority is now taking place almost some months down the line. And the outcome of that eventually could be that it gets referred to Jeremy Hunt, the Secretary of State, who can ultimately make a decision, and he will make a merits-based decision that we as lawyers aren't able to take about whether or not in fact it's a good idea to close Nascot Lawn.
Is it the first time a court has ruled against the NHS for breach of the duty to consult, overview and scrutiny?
I'm certainly not aware of many cases like it, and I think the reason for that is the obligation for a health authority to consult with a local authority is pretty clear cut. The reason why the CCG were found to have gone wrong in this case was because the CCG argued that Nascot Lawn wasn't a health service. Nascot Lawn is a service which was run primarily by nurses and was funded by the CCG. And so therefore their argument was, although it looks like a health service, effectively it isn't. Now, the court wasn't convinced by that, and indeed a significant part of our argument was that the needs of these children very much required a high level of care that kind of falls in that health side of the boundary. The court was with us on that and said this NASCOT lawn is a health service. The CCG then tried to argue, well, if it is a health service, we have in fact complied with the regulations, but the regulations are pretty tight, and the court gave that very short shrift, saying you clearly haven't done, and therefore the decision needs to be quashed.
It was Alex Rook who instructed the users of Hartley's Day Centre back in 2014, when they successfully challenged a closure by Shropshire County Council, which had failed to observe the common law duty to consult. We asked Alex if NASCOT Lawn was different.
One of the strange quirks of the NASCOT Lawn decision is that because we won on one ground and therefore the decision is quashed, it would be academic to try and appeal any of the other grounds. What the CCG said in this case was that they didn't have an obligation to consult. They had an obligation to enter into an engagement. That was something they were absolutely explicit about. Even in the meetings they had with families, they were asked, why are you not consulting? They were very clear, we're not consulting with you, we're engaging with you. I have to say, it was never clear to us, and this is part of what we said to the court, exactly what the CCG thought the difference was and what the consequences of that difference are. But the families were told in no uncertain terms, you are not being consulted with. Now, the case that you refer to, LH and Shropshire, was a case of mine that went to the Court of Appeal, and interestingly we lost in that case on the High Court and then won in the Court of Appeal as well. And the Court of Appeal said in that case, where you are withdrawing a service, that triggers that duty to consult. Now, we say that falls absolutely squarely within the circumstances of NASCOT Lawn. This was a service that my clients have been attending, some of them for over 10 years. It was being closed. There's no question it was being withdrawn. Therefore, LH and Shropshire says absolutely squarely, you must consult. And that obviously is a point that we were unsuccessful on. Mr. Justice Mossin doesn't refer to LH and Shropshire in the judgment, even though it was made very clear that was the heart of our argument. And that would have been a ground that we would have appealed at the Court of Appeal had we not succeeded on other grounds.
That was a case about changes to services straddling the NHS and local authorities. Our next case has been a long-running battle by campaigners seeking to prevent a reorganisation of hospital services in Banbury. A judicial review at the end of the year found for the NHS, and it will now go to appeal. We asked Rowan Smith, the instructing solicitor from Leigh, to tell us more.
So the background to the Horton case is that we represent a group of campaigners who for the last decade or so have been trying to protect services at a general hospital in Banbury, Oxfordshire. Most recent threat to the hospital came when the CCG decided to consult on changes, 3 of which were contentious. Downgrading of maternity, so removing consultants from obstetrics, closing beds, and also downgrading the urgent care centre. The fundamental error, we say, is that the CCG split the consultation into 2 phases. The first, on the 3 areas I just mentioned, opened in January last year, but the CCG said, don't worry about all the other services, we'll come back to you later once we've removed these services first. Ordinarily may not have been an issue, but for several crucial things. The first being that in a general hospital like the one in Banbury, the services are so dependent on each other, the staff, the skills, the expertise. And also the services in the second phase to do with A&E and paediatrics were clearly connected with maternity and urgent care provision. The High Court judgment dismissed the grounds on consultation, having acknowledged that the consultation was flawed, but then went on to conclude that that flaw wasn't serious enough to render the consultation unlawful. The problem was that the CCG actually produced evidence on the final day which seems to have swayed the judge into thinking that the interdependencies between the 2 sets of services wasn't strong enough. So even if there were flaws in the consultation, then consultees wouldn't have been able to say anything that would have changed the CCG's mind.
Now, interestingly, the Independent Reconfiguration Panel report that came out took a different view and criticised the NHS for the proposed two-phase consultation and ordered the parties to think again. In the meantime, campaigners have lodged an appeal. We now turn from health to a major urban regeneration scenario. There has been a long-standing political row about the London Borough of Haringey's plans to build thousands of houses in a commercial partnership with Lend-Lease. The Labour Party was bitterly divided, and it led to the ousting of Haringey's council leader, Claire Cober, a few months ago. In the meantime, Mr Peters went to the High Court, seeking to prove that there had not been adequate consultation. He was represented by David Wolfe, one of the top QCs in public law. The Institute asked him how he came to be so interested in the subject and about the Peters case.
I've been working on consultation cases all my time as a barrister, and indeed in some senses it was being involved in a consultation in a previous life that got me interested in the law in the first place. So I was a councillor in local government, and we were involved in closing some care homes back in the early 90s. And it was the process of that consultation that was one of the triggers for my interest in being a lawyer. So I've carried that through, and local government consultation legality has been a theme of my work for 25 years. We were refused judicial review permission after a several-day hearing, and it's now subject to an application for permission to appeal to the Court of Appeal. So it's ongoing. In terms of the underlying issue in terms of consultation, what the judge held was that the local authority should have consulted. The Section 3 best value duty required them to consult. They argued that they didn't need to consult at all. He rejected that, but he then said, but that Section 3 obligation had arisen 2 years earlier, that Mr Peters was too late to challenge the 2-year earlier decision, and therefore that was the end of it. Now, to my mind, that's not a right reading of Nash, and it's not what the law requires, because it leaves you with a very odd result, which is that if you've got a process of decision-making which is multi-staged, as the Haringey process was, if somebody comes along later and says, well, the obligation to consult arose at this point or that point, and nobody's challenged within 3 months of this point or that point, then somehow the consultation obligation withers away. Now, I don't think that can be right, where you've got a multi-stage process like Nash, because it means that you get to the end of the process with the local authority not having undertaken the consultation simply because nobody brought the judicial review at the right moment in time. And I don't think that can be right. Mrs Nash wasn't particularly concerned about the detail of the choice of particular commercial provider or the detail of the contract, and yet that was the decision she challenged. She was really indeed concerned about the decision that had been taken at a much earlier stage. So I think the situations are very different, and I would expect a different result out of the Court of Appeal.
Even though the scheme is politically dead in the water, so to speak, we understand that there will be an appeal, and it will be based on the fact that the issues which upset people in Haringey, things like the commercial terms and the accountability to councillors, could not possibly have been consulted on 2 years ago, because no one knew what the details were. We shall watch with interest. We will discuss one more impending appeal. It concerns the Help Refugees charity, who failed to persuade the courts that consultation on the Dubs Amendment was inadequate. Rosa Curling, the instructing solicitor, tells the story.
We were instructed by Help Refugees, which is an organisation which provides amazing humanitarian assistance across Europe, particularly to children, but also adult refugees across Europe. And we were instructed by them because when the Calais camp was being pulled down by the French, it was clear there was going to be a huge number of particularly young children, minors, left on the streets of France. The Secretary of State had a duty on her to specify a certain number of children to be relocated from Europe into the UK. And the number that she had to determine that could be relocated to the UK had to be done in consultation with local authorities. So this case has changed quite a lot during the course of the proceedings, but has become now a case which is about whether the consultation that the Secretary of State undertook with local authorities under Section 67(2) whether that consultation process was lawful. We took the case to the High Court. There was a divisional court who looked at the case. We argued that the consultation process was unlawful. Sadly, the divisional court disagreed with us, but we've now been granted permission by the Court of Appeal to appeal that judgment, and there will be a hearing in the summer of this year. In our view, the consultation that took place did not comply with the well-known gunning principles, the public law principles that determine whether a consultation process is lawful or not. One was that she failed to give sufficient information to consultees so that they could effectively and intelligently respond to her consultation. And two, we say that she failed to conscientiously take into account some of the responses she received. In relation to Scotland, there was a huge confusion by COSLA, who was in essence a kind of middle person between the local authorities in Scotland and the Secretary of State, about whether they had to respond to the consultation document about Section 67 and the numbers of children that they could basically accommodate. And we say that the Secretary of State, perhaps inadvertently, but nonetheless did fail to make clear that actually Scotland needed to respond to the letter that she sent out. There was confusion to do with a different resettlement scheme called the National Transfer Scheme, and there was a misunderstanding which meant that almost all local authorities in Scotland did not respond to the consultation. And we say the duty on the Secretary of State was to properly and intelligently and sufficiently explain to the consultees all of the information they needed in order to respond, and she failed in that regard. Similarly, there's an argument about the fact that the consultation closure date was very unclear. It was changed by the Secretary of State without notice to anybody else. It was also a very, very short period of time, and she refused to take into account the numbers offered from local authorities after the closure date that she chose. So again, we say she failed to properly tell people that they could effectively respond to a consultation, the deadline by which they had to respond. The number that's been determined, either that number will stay and there will be a reconsultation in any event to see if there are additional places. We think, from the evidence that our client has managed to obtain, that there are additional places which were either offered up and not counted by the Secretary of State, or in fact for various reasons weren't offered up. So we think if a consultation process was to happen now, we would find the number of 480, which is the current specified number, would be increased.
We wonder if she is right. Time will tell. So, if that is the evidence, what are the Institute's views? And for this, I've invited Rhion Jones, our founder director, to guide us in the interpretation of these cases. Rhion, we've had some fascinating insights from the lawyers, but why does the Institute find these cases so important?
Well, they're all different. The Nascot Lawn case is really quite interesting because it's a case where it establishes once and for all that you're going to lose a judicial review if you haven't consulted the health overview and scrutiny. That's a very important principle. I think Alex Rook needs to be congratulated. He has an amazing track record in consultation cases. He was the instructing solicitor behind the Supreme Court case at Haringey a few years ago. But of course, the case has stopped short of saying that you've got to consult whenever you're closing something, which is what his previous case with Shropshire had established. So there's a bit of a question mark there, and we are interested to see which way the common law goes on that duty to consult.
Moving to Horton Hospital, we find ourselves in a very familiar world where the NHS is facing case for change after case for change. They are lengthy, they are complex. So what's happening in Horton?
The point about Horton is that there is going to be a further consultation on further reorganisation down the road. But this particular consultation was about part of it. So it's really a timeline issue. Can you split two consultations without the one compromising the other? And the court said, yes, you can. Actually, the independent reconfiguration panel came out and said, no, you can't. So you have this problem that campaigners now have two choices. Do they pursue a legal judgment saying the consultation was unlawful, or do they go to the Secretary of State to see if the independent reconfiguration panel thought it was unwise? Now, in this case, the court said it's okay, which is why it's up for appeal, and the IRP said it wasn't okay and referred it back. Now, in a strange way, if I can move on to the Peters case,
yes.
because that's a different case, that's about planning, that's about urban regeneration, but actually it's the same issue of when do you consult on a particular issue. And Mr. Peters lost his case because it was ruled that by the time they came to challenge the plans with Lend-Lease, controversial as they were, political as they were, by that time the decision was taken years ago, and if you're going to challenge it, you should have challenged it earlier.
And that's sort of the echoes of the Nash and Barnett case that is always a centrepiece of our Law of Consultation court.
Precisely. That was about local authority budgets and the decision to outsource having been taken 2 or 3 years earlier than Mrs. Nash brought her case in 2013. So both of these are about the same thing. At what stage is it appropriate for you to be able to launch a successful challenge?
No one can fail to be moved by the plight of those children in Calais, the refugees. But isn't this actually somewhere we're in the world of politics?
Well, bearing in mind Windrush and all the other issues, Amber Rudd having lost her job over it, but when she organised the consultation about the number of children being taken in, the problems, I think, were at official administrative level. I mean, there was a big screw-up with the Scottish councils. I think most English councils didn't realise they were supposed to answer the consultation either. So when that goes on appeal, there could well be a lot of scope for the Court of Appeal to take a different view. And I suspect Rosa Curling's case will be quite a powerful one. But you're right, it's really in that twilight zone between politics and consultation, which you and I know well.
Well, we've just spent 3 years writing about it, and the book is coming out in July. So the politics of consultation has many stories like this, and this would be, were we to do a second edition, definitely another one in it.
The point, of course, being that the most politically charged issues often go to law, and it's very often the consultation that is one of the weakest part of the decision-making process, as I think the Help Refugee case will show. Yes, you're quite right. We've got a lot of that in the book, haven't we?
Absolutely. So let's move forward to where we're going to go next. This has been our first update. We know we've got a summer which is going to be full of new cases to look at.
I suppose the highest profile, certainly down in the southeast, will be the London case of the Mayor of London having done a consultation on closing police counters. The Institute having said it was one of the worst consultations of the year. That goes to the High Court in the next couple of months. That's going to be high profile. There is a case about an academy school called the Echo Trust, which people probably haven't heard of yet, but it will echo around the courts in a few weeks' time. Then we have some planning cases coming up. One is in Liverpool with the Ringrose Park. Should they, shouldn't they have expected Highways England to build a tunnel? That's going to be an interesting one. And in Northern Ireland, and we declare an interest because I think we've been advising on this, in Northern Ireland there is a gold mine being proposed that is fiercely opposed to by some of the residents, and that's going to go to judicial review in June. In Sunderland, we've heard of one. In Dorset, we've heard of one. And, of course, in the news was Calderdale because there's been another IRP report that has bounced that one back as between the respective merits of Halifax and Huddersfield and the very controversial plans they've had there.
So I think our next update is going to be a full one, and please watch out for it because we hope you've enjoyed this one, but there will be subsequent ones for you to have and find of interest. Thank you, Rhion.